Hey, good morning, everyone. It's Law and Legitimacy. Norm and Mike are back. We're going to do our best to do an hour today, but I got a hard stop in an hour because I'm doing court at 10:30. And as you'll know, yesterday I was an hour and 15 minutes away, so I got to hit the road, Jack, and I will come back some more. And so are you here on LAL. And Mike and I have a question for you. Sit down, put your cup of coffee down. If you're driving, hands on the wheel, 10 and 2, pay attention. But this is a significant question. Why do you go anywhere else for legal news or listen to things? Didn't we tell you yesterday was likely to be the day that the Supreme Court ruled in the Harvard and North Carolina affirmative action cases? Didn't we tell you it was likely to be a 6-3 decision? It wouldn't be 5-4, probably not 6-7-2. And didn't we tell you that the Supreme Court was going to overturn affirmative action? And didn't we suggest that it was going to be led by Chief Justice John Roberts? Well, guess what happened?
Yes. Answers to those questions, Norm.
So kaboom! There it is. And now the internet is on fire and the Republic is in jeopardy. None other than Pocahontas Warren, as I refer to Senator Warren, has declared that this is another act of an extremist Supreme Court that is placing the future of Western civilization and all that is good, true, and beautiful at risk. You know, I don't even know where to begin. With fair admissions, students for fair admissions versus Harvard and UNC. It's a complicated case. There are hundreds of pages of decisions. I think it comes to about 250 pages in general. There's the writing for the majority is Chief Justice Roberts, Justice Thomas concurs, Sotomayor and Ketanji Brown O'Shea, who I can't say what a woman is, have dissents, as does Justice Kagan. We will talk about this case in the country. We'll debate the case for years. But as of this moment, the Supreme Court has held that race cannot be used as a factor in collegiate admissions. And it cannot because it violates the Equal Protection Clause. This is a ruling that will resonate, in my view, through the country in ways far more significant than Dobbs versus Women's Health Center. Dobbs versus Women's Health Center, you'll recall, was last year's explosive case, decided at about this time, leaked to the public well before it occurred, and we still don't know who the leaker is, or we still don't know who took the leak, to be a little vulgar about it. But that case returned to the states the ability to regulate abortion. I'll call it what do we call this? I guess we'll just call it the affirmative action cases. These cases do something far more. They don't return a power to regulate on the basis of race to the states. They don't reserve it to the federal government. They simply eliminate it altogether. And so this case becomes an amazing teaching moment for what the Bill of Rights does. The Bill of Rights, people say, well, we're a democracy. What the will of the people triumphs. Yes and no. We have votes. We have democratic institutions. The arc of authority bends toward democratic control in the United States. But in the end, we place certain things beyond the limits even of a well-intended majority. And among those things are the rights guaranteed by the Bill of Rights and the rights guaranteed by the United States Constitution. So we have the 14th Amendment, which guarantees the equal protection of the law.
I could just bathe in what you just said. Can you repeat that again, talking about,
bathe in it? Man, you must be
regarding, I guess guarding against even a well-intentioned majority. Can you explain a little more? Because one thing that has brought you and I together is your, I don't want to call it a suspicion, but your aversion to the mob, right? The notion that society sort of hangs by a thread. It's a bit of a miracle that we're able to conduct ourselves in the manner that we have. And, the mob mentality is majority rule, and a self-righteous mob, even well-intentioned, can do harm. Am I getting that close to correct?
Well, you're getting it dead right. I mean, I've reduced it to a sentence. There is no mob there is no force quite so dangerous as a self-righteous mob, or people who think they have a monopoly on virtue are capable of just about anything. They can burn you at the stake. They can ostracize you. They can kill you. They can decide that you're, 3/5 the person, or in our time, that you owe other people something simply on account of your immutable characteristics. virtue, justice, the good life. These are dreams. These are the aspirations that have inspired political philosophers for millennia, and courts insofar as they aspire to do justice. If in fact that's what they do, share some of those aspirations. And so what the Bill of Rights does is say, look, enthusiasm. So in the Enlightenment, there were lots of discussions among philosophers about the relationship between reason and the passions. There were lots of discussions and fears about the danger of enthusiasm, that is, having your passions run away with reason. And so I think there's always been a recognition that a mob is capable of anything. And you know it to be true. You go to a ball game and people start hooting and hollering, and the next thing you know, you're screaming at the top of your lungs, and you may have forgotten the name of any of the players on the field, but you're part of a group, and by golly, that group wants the home team to win. And when the crowd roars, you roar with it, not because you've made a reasoned calculation that your roar will serve the greater good, but because it feels good. It feels good to be part of a crowd. It feels good in that instant to become part of something larger than yourself, and at that moment to be relieved from the terror and the uncertainty and the all too certain fact of your own mortality. In illusions of justice, there is a whiff of immortality. There's a whiff of perfection. There's a whiff of the good, true, and the beautiful. And that whiff, I tell you, is dangerous to people who don't share your view, because when they get in the way of the good, true, and the beautiful, they become ugly, false, and evil. And what do we do with ugly, false, and evil people? We cancel them. We eliminate them. We try to reform them against their will. And so I would suggest to you that whenever you have political institutions that have the power, that possess the power, or believe they have the right to possess the power to define the good life, you have a situation in which minorities, in which those who don't share the view of the majority are at risk. And so to my mind, the genius of the Bill of Rights is that it says that that we are a republic, that notwithstanding the will of the people in a given moment, there are some rights that are so fundamental, some rights that reach back so far and are so settled as to become, if not immutable, all but immutable. And we will erect a constitutional structure to place some things out of play, or in the alternative, to place hurdles before which they can be placed in place so great that we have assurances that the law's protection really does extend to everyone, not just to everyone we agree with. And so the Bill of Rights, in my view, stands outside the structure of government and places a limit on what government can and cannot do. We have a government of implied and limited powers, arguably, on the federal level. We have state governments that have police powers and expansive powers, and all are filled with officials elected by democratic norms and with officials appointed through representative means. And they all act in goodwill, I think, except when people are stealing, like, the Biden family. But they all act with goodwill to accomplish their vision of the common good. And when they seek votes every 2 or every 4 years, they're trying to mobilize voters around common interests, common ideas, common visions of the good. And sometimes those enthusiasms can be bad for those who don't share them. And so the Bill of Rights just says, whoa, wait a minute. The constitutional amendments say, whoa, wait a minute. And one of those wait a minute moments is in the 14th Amendment and its guarantee of equal protection for all. And so I believe, and I may have a chance to do more than just scan the affirmative action cases yet. I've been in trial and returned to trial today. The nerve of the Supreme Court to release a major decision when Mike and I, at least I, don't have time to digest it fully for the morning's next show, but I'll have a chance to read it over the weekend. But the bottom line is this: the Fourth Amendment's guarantee of equal protection of the law says, folks, equal means equal. And while we have a unique history as regards race relations in the United States of America, there comes a point where equality isn't just an aspiration to be accomplished at some future date, but it becomes a reality now. And so right now, at least with respect to college admissions, the law is race can't count. You don't get the benefit of the doubt because of your ancestors or however,
Well,
whatever.
to be clear, Norm, that is how the law has operated up until 2003-ish, right? So, equal protection is not something new, and the preclusion of, I guess, race-based decisions or racial discrepancy across the board in America has uh, long been something of, I think, an ambition for society post Civil War, Reconstruction, and those things. And if one were to go and read the full balance of these opinions, in particular, Justice Clarence Thomas's concurrence in this case, he goes on probably a 20-page historical timeline trying to build the anchors and the foundational cornerstones of why this decision is being made now and upon what grounds. And it's a historical look back and an attempt to bring the reader into a current frame of reference and to recognize that the past 20 years are not the past 200 years. And I think that that's a key feature of this case, Norm.
Well, it is. It's a key feature of the court's reasoning. But my understanding of the opinions is that they suggest justices living in different worlds and bringing different analytic tools and assumptions to the decision of a case that I think in the end will not do the Supreme Court a lot of good. Now go back to Pocahontas. I think in the end it won't do the Supreme Court a lot of good because people are going to be inclined to see the policies and the politics and the perspectives that justices bring to bear on this case and see nothing else. And and the fact is, with regard to race, this country, it's a disaster. I mean, at the time of the founding, we had the 3/5 compromise in order to get the South and the North together to agree on a constitution. Our constitution said that for census purposes, people of color were counted at 3/5 of a person, but they weren't permitted to vote. And under and then came the Dred Scott decision in the years before the Civil War that said that African Americans didn't have rights that white men were required to respect at all. And so in the run up to the Civil War, we had vast and deep sectional divisions versus free and slave states. We had an attempt to impose national law in the form of the Fugitive Slave Act and open defiance of that law and prosecutions regarding it. We fought a civil war. During the course of the Civil War, African Americans were emancipated, at least in slave states. The 14th Amendment then, declared that all persons were created equal. And in the course of putting the country back together again during Reconstruction, Jim Crow laws evolved in the Old South, where we may not have had de jure, that is, by law slavery, but we had a de facto divided country. And those divisions persisted into the 20th century. And it was not an uncommon thing to have race riots even as late as 1968. The result of that was a series of federal laws that were designed to focus on racial disparity in conditions and to address them, to eliminate overt de facto forms of discrimination, and to empower all people to claim the equal protection of the law in areas of public accommodations, public goods, and so on. And so, I think from the perspective of those who are distressed this morning about the affirmative action decisions, that struggle should continue. The inequalities persist. I mean, like this week, I had to chuckle reading the newspaper or the online feeds. Apparently in vast sections of the Midwest, the smoke incident to the Quebec wildfires continues to affect populations. And so, newspaper headline, minorities and people of color affected by the smoke. And I'm thinking, what does that mean? Like white people have superpowers? I've got lining on my lungs? No, but the claim is always going to be that as a result of historic inequality and systemic racism, which according to the New York Times, the 1619 Project, imbues our society, infects every element of it, sculpts the outer limits of everyone's life chances, insofar as white people are presumed to have more inherited wealth, and many do. I mean, I don't know about you, Mike. I inherited $5,000 along the way in my life. That's all I got. It didn't give me a leg up on the next guy, but I guess it's 5,000 more than I would have had. I spent it a long time ago on what I don't recall. But there are those who believe that our society, a lot today, even now, look at 2020. I mean, you've got George Floyd passing counterfeit bills. A cop comes to the scene. There's a confrontation. Floyd can't breathe. He dies. It's a horrible event. He died in police custody. There are powerful arguments that Derek Chauvin violated police procedure in the manner in which he continued to subdue Floyd when he wasn't resisting. But you look at the tape and you wonder when was he ever going to stop? And then you realize that each year, hundreds of people die in police custody, and some of them are foreseeable, and not all of them are culpable. Meaning, not all officers are culpable. Sometimes people bring their deaths on themselves. One way of looking at the Floyd tapes is, if he had just cooperated for 30 seconds. This whole thing would have been different, but he couldn't, and he didn't, or he wouldn't. And, the question is, was it because he was intoxicated? Was it because he was mentally ill? Was it because he was willful? Chauvin wasn't required to diagnose him and treat him. He was permitted to subdue him. Did he cross the line? A jury said he did. But what was interesting about the Floyd case is this wasn't regarded as an isolated tragedy involving an officer with scant training to deal with a man with polysubstance abuse, mental health issues. It immediately became a poster child for protests throughout the country in which people were enraged, saying, look, this is police brutality. Everything is systemic racism. It's hatred all the way down. And we must redress this by remaking society. No justice, no peace. And so when some of the protests turned violent and there was arson and looting, there weren't really many prosecutions for the arson and looting. It was more or less excusable as what I would call a sort of ad hoc, spontaneous, street level form of reparations. Those sentiments aren't destroyed by yesterday's decision. In fact, they're fanned, and they're fanned by none other than Elizabeth Warren. Here's her tweet on the screen. An extremist Supreme Court. I mean, you could call John Roberts a lot of things, but calling him an extremist is sort of like calling Elizabeth Warren a Native American. It's just kind of got the smell of bullshit to it. An extremist Supreme Court once again reversed decades of settled law. Well, I came up, I'm an old man. I was going to college in the 70s, and I remember the Bakke decision. And I remember thinking, wait a minute.
Which is referenced throughout this opinion.
And so Bakke was Bakke versus the Board of Regents, I think, of the University of California. He was a medical school applicant, denied admission, and someone of color got it who he claimed had equal or lesser qualifications. And the school's justification was that pursuing a diverse student body was better for society. And Bakke couldn't help but feel insulted. His dreams were frustrated by a social engineer who concluded that his spot should be filled by someone who looked differently because somehow this would be better for society. And I would suggest to you that a lot of the populist discontent with experts stems in part from this kind of reasoning, because somebody's trying to tell us what's good for us, how it is that we should live. And in the effort to make a better society, our public institutions and government may do things that would have surprised the founders, may do things that would surprise a lot of people who believe in limited government and who believe that individuals should have the right to choose for themselves how to pursue a vision of the good life, and that the good life doesn't come from top down. The good life comes from bottom up. The true form of inclusion, what creates a healthy society, isn't imposing quotas from the top down. It's assuring excellence from the bottom up and giving people the means to succeed. And so someone like Bakke felt betrayed, I suspect, by a system wherein he worked hard, presumably hard enough to be a credible admittee to a medical school, and his place was given to a person of color. He sued, and the Supreme Court embraced its complicated relationship with a compromise on equal justice before the law. It did so because it was persuaded that it needed to recognize centuries, decades of injustice, and that our institutions had a right and and maybe even a responsibility to seek to address it. But how long does that last? My view, I'm celebrating the affirmative action cases because I think the body of law implicit within them is a death blow to reparations. I mean, good grief. If you can't use race to decide when to let someone into an elite institution, are you going to use race to tax somebody now for the benefit of persons of another skin color? If you're going to say race can't be used, for elite institution admissions, you're certainly not going to permit differential tax treatments, are you? Are you going to say that we can have minority set-asides now, or opportunities should be given to someone in a working class context or in a working context when those same opportunities might be denied them on account of race in an institution? Somebody like Elizabeth Warren says the social experiment isn't over. An extremist Supreme Court has once again reversed decades of settled law. When we're talking about decades of settled law, we're not talking about laws that were intended to last forever. We're talking about laws that had a limited horizon. The laws were designed to eliminate the vestiges of history. Now, however, we live in a society where that history is taught and it's received dogma. And the message from that history is one of entitlement going forward in perpetuity. An extremist Supreme Court has once again reversed decades of settled law, rolled back the march toward racial justice. Plenty of people don't think that march is going in the right direction. If you're a white guy who is denied an opportunity and it's given to someone because
or an Asian
race,
guy,
or an Asian guy, or an Hispanic guy,
as in this case, right?
And it says it's narrowed educational opportunity for all. I just don't buy that. It hasn't narrowed educational opportunity for all. It has increased the prospects that some people at the margin will be admitted, and decreased the prospects that at the margin others won't. But these institutions are going to have no shortage of candidates. It's funny. I heard from a young guy on his way to law school yesterday. He had good grades, but not superb. Very good SAT scores, but not superb. He applied to a bunch of mid-range law schools, got into some, but not all. Was offered a great scholarship from one, but not all that he was admitted to. And so in the end, he's made an economic decision, and he's off this fall to the school that offered him the most money. The school that he would have preferred to go to didn't make him an offer. So he's like, geez, I guess I waited. I should have waited another year to apply to law school. Maybe now, maybe. And it's these cases at the margin, I think, that really matter and that shed a light on equality before the law. So, here's Warren. I won't stop fighting for young people with big dreams. Well, tell it to the young white guy who didn't get into Harvard last year because Harvard wanted to let in somebody with lesser qualifications who happened to be black. What happened to his big dreams? And is it really a big dream if your work is disregarded on account of your skin color? You don't have an equal chance to pursue your future. You're going to give a leg up to somebody because of their generation, of their descendants. Elizabeth Warren, I looked at this. You showed me this yesterday, Mike, and I thought, man, I am so glad that she has become a marginal figure in national life. I mean, can you imagine her running for president?
This tweet is the most important thing she's done ever. She got ratioed. For those who don't know what ratioed is, I think there was something like 20,000 plus comments on this. But she's only getting 6,500 likes, 1,400.
I don't know what ratioed means myself.
Ratioed means that when you put something up and you can look at the data points that are under it. So if I back off of this tweet and I just look at it in the normal timeline, you'll get an indicator for how many people have responded or replied to the tweet directly, which is usually a signal of disagreement, right? The larger that number is, the more likely that whatever the substance of the original tweet is something that the population of people who are viewing it disagree with fundamentally for one reason or another. And so that ratio is off. Typically you want mostly retweets and a lot of likes, right? But if that ratio is reversed, where you have, a rather paltry number of likes by comparison to the number of responses, and that's what's happened here. I think this is somewhere north of 25,000 comments directly responding to this tweet, but she's only got 6,500 likes netting out of that, right? Which means that the response to this has been overwhelming, and it's gotten 5.5 million views, right?
So, Mike raised an interesting point yesterday. Like, what's our take going to be on this? I wanted to get into the weeds and nerd out on the decisions, and we'll do that probably next week. But Mike was, look at all these lawyers, and so here's Elizabeth Warren, a product of Harvard Law School. She's lost her mind.
Who has admitted to claiming Native American heritage on her application into law school, and took a blood test that came back and showed that she was 1,024th.
That proves it.
Native American. I mean, how rich is this tweet?
Let's move on. Let's move on.
You know what I mean?
So others responded. Who else?
So here's Barack Obama, another Harvard educated lawyer.
Affirmative action was never a complete answer in the drive toward a more just society. No, reparations would help. But for generations of students who'd been systemically excluded from most of America's key institutions, it gave us the chance to show we more than deserved a seat at the table. Let's unpack that statement. There is no student who has for generations been systemically excluded from most of America's key institutions. Individuals live in their own generation. And so if my grandfather was excluded from an institution, I was not. If my father was excluded from an institution, I was not. If I'm included in an institution now and somebody else is excluded because of, then they are not. They are not included. They are excluded. And if we're going to include and exclude on the basis of race, that can't help but to sow resentment. And so when Barack says it gave us the chance to show we more than deserved a seat at the table, there's no question in my mind that there is a surfeit, that is an overabundance of qualified candidates for elite institutions. When I was a young nerd, I was on the admissions committee at Columbia for the graduate school for a while. And, it was boring. I mean, there were so many kids with perfect GREs and perfect scores and glowing letters that for me, when I looked at an applicant, I didn't look at their letters. I didn't look at their grades. I didn't look at their test scores, except to determine that they were sort of like in the minimally genius cohort. The question I had was, do I want to spend any time with these people? And so for me, the key to admission was be an interesting person. Don't be a data point. And one of the data points that we're using to admit people now, or at least were, was race or identity. And I think that just can't help but say to some people, your life matters more than others. And if we're ever going to have a commitment to equality of the law, when is it going to start? And I think Robert says it starts now.
Well, look at what I've got on the screen here.
Who's Roy Cooper? Is that knucklehead in that place you call home?
This is the lame duck governor of North Carolina.
This is the guy who gets vetoed it's the veto of the week thing. Roy Cooper here's Roy Cooper,
this
governor of North Carolina.
Too, Roy.
Hey, honey, how'd you like to go out for dinner tonight? I thought we'd get us some fish. Vetoed. Okay, good. What are we getting? Steak, Roy. Man up and eat it. But vetoed. Anyhow, what's Roy got to say?
He's just getting overridden at every turn. So he says this decision undermines decades of progress made across the country to reduce systemic discrimination and promote diversity on campuses, which is an important part of equality education. Now, this is bolded, but this is also I put this up because the Grutter v. Bollinger decision, the Michigan law case, where the Supreme Court
that was 2003, was it not?
That decision was handed down in 2003. And the court in Grutter v. Bollinger talked about the compelling government interest. And Norm, this is what I want you to do now for us to set this up, for us to do a deeper dive, either, now or into next week. And I think it'll probably be both. But the scrutiny that the court applies to something that implicates an equal protection claim is the highest that the court can provide, right? It is saying that in order for this to be lawful, the person or the entity that is attempting to do this thing or these things must show a compelling government interest. They must show that it is as narrowly tailored. In other words, there is no less intrusive way of accomplishing the goal. And then in the case of education, as they've put forth, that there's some finite end date, to what they're doing. The central issue is that this saying promotion of diversity on educational campuses is somehow a paramount concern for universities. And now I want to be careful here, because there are many ways that you can take a bite at that apple. One thing that is very clear is that in order to say that diversity is important, and then also link that to the facts of this case, the only way that one can do that logically is to create a monolith of those various elements of race, right? To say that cosmetic diversity is an important part of a quality education. In other words, everybody of a certain skin type trends to think and do the same things. And as such, it's important to have a composite of diversity, because there's no way that we can show that intellectual diversity or, intellectual pluralism is really what we're going for. There's something inherently important about representation of various skin colors in certain proportions in and among the educational experience. It's important not only to the people that are getting in based on some sort of race-based admission practice, but it's as important or tantamount to the education of those peers that they will have in their classes. This is the serious position that these institutions take. And so what the court has said is that in Bollinger, they recognize that a law school, Michigan Law School, could say that it is a compelling interest in an initiative and an ambition of the institution. It is within their discretion to say that diversity is an important aspect. But what they did explicitly, and this is what you're not hearing anywhere that is serious about dissecting this opinion, what they did is say explicitly that it should take no longer than 25 years, that this will be
was the Bollinger
unlawful
decision, right? Yeah.
in 25 years from that date. Well, guess what? We're at the 20-year mark now, and there are at least classes of people who are applying to law school, and this has been addressed. But the opinion of the court was as such. It was, not only do you guys not articulate here a compelling interest in diversity, right, even by statistical and historical figures, and not only have you represented that this race-based admissions process doesn't have you're not creating undue harm in applying them, but you can't even say with particularity when you'll be done, when diversity will be met, when this goal will be attained and obtained within the educational framework, because this court allowed institutions like Michigan and Harvard and every other elite institution, namely Ivy League institutions, to begin making decisions in the admissions process based on race, due in direct part to the decision in Bollinger. And so what this case does is recognize that these institutions never set about to accomplish the goal that they in good faith lobbed to the court back in 2003. And as such, we're done pretending that it's a compelling state interest.
Well, there's another way to look at it too. And so, the Bollinger, we talked about the Bollinger language earlier this week, or maybe late last week, without citing the name. Thank you for reminding me of the case name, Mike. And I do you recall who was it that talked about 25 years? Was it Sandra Day O'Connor in that case? I think in
Bollinger?
Yeah.
I actually think it was the 25 years was from a previous decision that they took.
Okay, well, in any case, so I am open to the look. I'm a criminal defense lawyer. I'm out and about and in small urban communities in the Northeast that are of mixed race, and the criminal courts are filled largely with Black young men. Or people of color. They are disproportionately represented in the criminal courts. Why is that? It's not because, is it because Blacks are criminal? They have a predisposition to criminality? Or is it because how we define a crime has a disproportionate impact on people who happen to be Black? Or is it some other factor? Or can you eliminate race from that equation altogether and say that crime is a function of lack of opportunity? And sometimes it's a function of lack of a will, sometimes it's just a function. Sometimes people are just bad. But I think the badness cuts across racial lines. It seems to me that a better way to think about a healthy society is a way to think about creating opportunities for all and holding all responsible for maximizing the opportunities they have. I think where the affirmative action cases went too far is they said, look, it's society's role to assure that everyone has an equal opportunity, even if that means depriving some people of the opportunity that they would have had but for the color of their skin. And I think that we're living in a time now where that's beginning to backfire. And I would suggest, again, the great neglected book of our times was the Ann Case and Deaton book on deaths of despair. If you look at flyover country in the Midwest, death rates among white working class men are skyrocketing. And these deaths of despair are a result of alcohol, drug overdose, or out and out overt suicide, handguns or otherwise. And it's because they feel somehow a lack of place in the country. Is it because their jobs have been outsourced? Maybe. Is it because we've opened the door to floods of immigration and we're giving unlawful immigrants free hotel rooms while these people are being evicted from their homes? Maybe. Is it because we're saying to them that your job is going to go to a person of color because their grandfather was enslaved and your children are not going to get into Harvard while somebody else does because they can jump and white men can't jump? Maybe. And so I think that if we're going to build a better society, I think a commitment to inequality has to begin sometime. And I think what Roberts says is it begins now. Now, Mike, what you're saying is, we've been sold a bill of goods. There was a promise to use a limited tool, and in a generation or so, that tool would have remade society. The question is, has society been remade? And people will endlessly debate that. But the strict scrutiny test, you're right. You won't find, so the law talks about intermediate scrutiny, strict scrutiny, but let's look from the top down: strict scrutiny, intermediate scrutiny, and rational basis. And when evaluating a law, a court applies one of these standards to the law to determine whether the law comports with constitutional requirements, in this case, the 14th Amendment. Those of you on your way to law school, pro tip, okay? Master strict scrutiny, intermediate scrutiny, and rational basis review, and then look for the question on the exam that asks you to show your mastery of that. That will get you at least a B range grade on the exam, guaranteed. How do I know that? Because when I got to that question in my law school paper, I said, that's all a bunch of well, I didn't say horseshit, but I said, courts have talked about varying standards of review. This is judicial tyranny. This is nowhere in the Constitution. We, the people, never would have consented to that. And then I wrote my con law essay on Thomas Hobbes and John Locke, two 17th century British philosophers. Needless to say, I almost flunked con law, which is somewhat ironic because now I practice it.
Sir, this is a Wendy's.
Strict scrutiny, as Mike pointed out, is the government must identify a compelling interest. That is, it has to have a legitimate interest in something, and it needs to be compelling, important. It needs to be so important that we're going to potentially bend the facial application of a rule in the direction of that interest. And the remedy that's being offered has to be narrowly tailored to achieve that interest. And so I think with respect to, and by contrast to the lesser standard of review, a rational basis test, that doesn't typically evolve fundamental interests or constitutional rights from the Bill of Rights, but a rational basis test is simply Congress has to have articulated some good reason for doing something, even if it's stupid. And in that case, the court will typically stand down. But when it comes down to fundamental interest and equal protection of the law, the court says that before we tinker with that, we have to have very compelling and important reasons. And for decades, the Supreme Court was prepared to bend the law in favor of inequality, to deny equal opportunity to some Americans because of the compelling interest in making up for a history of discrimination and past intolerance of diversity. The question becomes, at some point, do we stop bending the rules to serve history, and do we start living in a contemporary universe where all people count and are equal? And Roberts and the sixth majority members of the court say we've arrived at that point now. What are some of the Dawn McNeil? I want to address Dawn's point. Welcome, Dawn. You're a new arrival here, and your contributions are greatly valued. even though I know it's past your pickleball time. I know the other day you left with us to go play
Norm, let's go
pickleball.
ahead and transition now into the AMA segment. I know we've got about 20 minutes left before we got to get you out of here. So our promise to the viewers is that we will most certainly dive back into this case.
Oh yeah, I mean, I haven't even read it, had a chance to read it yet. I can't wait.
And I have, and so I don't want to use that as I don't want to blow my dry powder here in a conversation with Norm. But I've read it, and I've read it in full. In terms of the concurrence and the dissents. And there's one thing interesting. Ketanji Brown Jackson, I did actually.
Yeah, tell us about this. So Ketanji got nuked in this decision. I mean, I don't know how. So there's a tradition in the Supreme Court that's very formal. They meet in chambers before arguments. They shake hands. They go out. They come back. Everybody speaks in a certain order. And one of the reasons they have these traditions is these guys and gals lay it all out on the line in their opinions, and they're expected to be vigorous. I'm not sure that Ketanji Brown's going to be or Ketanji Jackson is going to be inviting John Roberts to her house for Christmas this year, though. What did he say about her? And what did she do to deserve it?
Well, it's both Thomas and Chief Justice John Roberts. And Ketanji Brown Jackson had a number of appeals to statistics, the inherent wealth of certain classes, and really just a general appeal to, I guess, continuing along this sort of amorphous timeline with respect to race-based preferences to right historical wrongs, and was more than willing to essentially conjure something completely new and abandon any semblance of stare decisis in so doing. The most cutting criticism came not from Chief Justice John Roberts, but from one Justice Clarence Thomas in his concurrence, which he did, and I think was probably something that everybody should have expected him to do, because while, Norm, you predicted that Chief Justice John Roberts would deliver the opinion of the court, anyone who's listened to me talking about the Michigan law case knows that was a seminal moment in my law school tenure, was reading the concurrence/dissent that Thomas gave in the Bollinger case. And for that reason, being on the other side, having that come full circle, it seemed as though he stepped out and allowed Chief Justice John Roberts to deliver what would be the functional majority opinion. But Justice Thomas had unfinished business stemming from at least 20 years prior, right?
But Ketanji said something about how we needed to. I think one of the more amazing tells in Ketanji's decision was her urging, or her suggesting, that the court, quote unquote, needed to leave what makes a good society to the experts. And we've talked before. There was, in an old episode, we talked about the four movements in constitutional law, and that the movement that is defining our time is the development of a public health state, wherein every mimetic, every meme-worthy statement that you and I have pointed at and be like, that's patently absurd, that's ridiculous. That seems to be what she's operating on, is this sort of this internet digital wave of establishment media, whatever. It's just this is the same justice who, in her confirmation hearings, could not or would not define what a woman is, right? But she wants to leave it to the experts to decide how to redesign society, so long as those experts agree with us. There's a very selective ability on her part in being able to define certain immutable characteristics of individuals, right? So how did she get blasted? Give us a taste. I'll read this one. Thomas says in relevant part, nor do Justice Jackson's statistics regarding a correlation between levels of health, wealth, and well-being between selected racial groups prove anything. Of course, none of those statistics are capable of drawing a direct causal link between race, rather than socioeconomic status or any other factor in individual outcomes. So Justice Jackson supplies the link herself, the legacy of slavery and the nature of inherited wealth. This, she claims, locks blacks into a seemingly perpetual inferior caste. Such a view is irrational. It is an insult to individual achievement and cancerous to young minds seeking to push through barriers rather than consign themselves to permanent victimhood.
If an applicant has less financial means because of generational inheritance or otherwise, then surely a university may take that into account. If an applicant has medical struggles or a family member with medical concerns, a university may consider that too. What it cannot do is use the applicant's skin color as a heuristic, assuming that because the applicant checks the box for, quote, black, he therefore conforms to the university's monolithic and reductionist view of an abstract average black person. Accordingly, Justice Jackson's race-infused worldview falls flat at each step. Individuals are the sum of their unique experiences, challenges, and accomplishments. What matters is not the barriers they face, but how they choose to confront them. And their race is not to blame for everything, good or bad, that happens in their lives. A contrary, myopic worldview based on an individual's skin color to the total exclusion of their personal choices is nothing short of racial determinism. Justice Jackson then builds from her faulty premise to call for action, arguing that courts should defer to, quote, experts and allow institutions to discriminate on the basis of race.
Bingo. That's a Kapowie moment. Hey, what's this? What do you mean, Gold Store, Connecticut? That I've got oxygen hooked up to his ears? I love you too. Hey, let's go back. I mean, that's an interesting comment. And so Thomas, of course, Thomas is now going to be called Uncle Thomas. Not
going to be. He's been. Again, I tweeted yesterday something like this, Norm. I said, I would, ask some. I think I tweeted something to the effect of, I would ask why we should believe that so many people have read the opinion, but that would skip over the important question, which is like, why are we to believe that so many people can actually read?
Yeah, fair enough. Dawn McNeil asks, diversity on campus as a value was the justification for discrimination and integration of public schools and busings. Will this decision affect all corporate emphasis on diversity in hiring? It could, because I misled everyone. I said last week or earlier this week, I said that the North Carolina component of this case arose under Title VII. It didn't. It arose under Title VI of the Civil Rights Act.
There was a Title VII case, but it wasn't this one.
Yeah, no, I realized that, but I wanted to correct that because when I read that, I thought, bing, 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 time for a correction on Law and Legitimacy. There is no oxygen being pumped into Norm's ears through his headset. It is in fact nitrous oxide, and that's why he's talking trash. But in any case, the Title VI claim arises from discrimination when an entity receives federal funding. I think that this case, Dawn, opens the floodgates for litigation in every context in which race counts. And so in a Title VII case involving employment, there will be litigation relying on this. In any entity that receives a public benefit that discriminates will be sued. Dawn says, will people find ways around this ruling leading to endless lawsuits? Yes, and yes, some more. I mean, there's a reason why when you walk into a law office, at least there used to be a gazillion books with bindings. Those are all reported decisions. A case gets decided and then there's spin-off litigation for years to come. So I think what the decision does is throw down a marker and basically says, we're going to litigate questions of race now in an endless variety of contexts. The press will be on in the 2024 election to elect a candidate. And this is why we began this segment of the show today talking about the difference between a democracy and a republic. And candidly, there may be no way out of this box. I'm not going to take the view that the founders were geniuses who created the perfect government for all time, and all we have to do is read the Federalist Papers and we'll live happily ever after. No. All life is an experiment, and it's an experiment that is bounded by general rules, and sometimes
I almost forgot. Thank you, freedom
better than others. And so, I see that too. But so I think what we have now is an invitation to a new struggle. And so in the presidential election, the claim will be that the majority's will has been frustrated, that Black Lives Matter and everybody must be able to abort everywhere, anytime, whenever, for whatever reason. And let's get a candidate that's going to pack the court with people who have those views. And, I'm not going to say that's a move that we can make politically, because in the end, we're going to have a court filled with 9, or make it 11. You want to pack the court, make it 13 justices. And those justices and their policy perspectives are going to be the filter through which narrow doctrinal decisions are made. And the majority and dissenting opinions in the affirmative action cases show the importance of those filters. And so in the end, law is simply an epiphenomenon. Law is not what creates a society. Law reflects the underlying society. And the general terms that we say we are governed by are capable of very elastic and different meanings depending on your perspective. So I think the 2024 presidential election just got a lot hotter. And, it may well be that there will be a liberal or radical equivalent to the Federalist Society. This is why people hate George Soros and his Open Society initiative. Will he have a living Constitution Society with Ketanji Jackson as the first open speaker? We need to create a better world. We want to trust the experts, and we want all of you who've been trained in DEI and social justice warriorhood to go to law school so that you too can legislate or tell us from the bench what justice requires. Robert Kennedy Jr. looks like he's going to be in this club as well. What's up with him?
So, I want to address photography says, so this decision will do more to stir the pot than rectify a problem. And this connects with T-Girl. Hey, T-Girl. And I promised I would try to get back to your comment from much earlier. T-Girl says, I thought admissions could still employ a proverbial, quote, victim impact statement. How societal biases have impacted a prospective applicant. And that's right. And I think also Harvard came out shortly after this decision was handed down and kind of intimated that they were going to shift this burden just to the essays, right? To the essays portion of their application. And that's due in direct consequence to something that Chief Justice John Roberts said in like the waning sentences of his majority opinion. If I can find it real quick, I'll throw that up on the screen for you, Norm. But I think that what I was going to suggest in response to photography's comments there was that this is mostly an invitation for those that feel strongly and who have the capability, whether it's a law degree and a bar license or otherwise, to join in to hold our institutions and our in the private sector accountable for this decision, right? So yes, it will be a bit of a mess. It'll get worse before it gets better, as the saying goes. But I read this as more of an invitation, right?
Well, I think I hear you, and it is an invitation. But photography, people. We talked yesterday about individuals and as tokens on the board, as it were, and the rule of law defining the moves that they can make.
Here it is.
The board changed a little bit, and the tokens on it are now going to maneuver in terms of their interests as best they can. So there'll be challenges at the margin to this decision, attempts to distinguish this from other contexts. And I suspect that this case will become, for race relationships, for the next 40 or 50 years in this country, what Roe versus Wade was for the right to abortion. There will be a concerted effort to try to overturn it or to claim or to limit it in one form or another in an endless series of litigation. You had a comment on from the
so Chief Justice John Roberts, just to get at the comments and the questions there. So at the very end of his opinion here, you can see Thomas's concurrence starts right after this. He says, for the reasons provided above, the Harvard and UNC admissions programs cannot be reconciled with the guarantees of the Equal Protection Clause. Both programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner. So that is strict scrutiny, everyone, right? Unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints. Boom. There's the whole legal standard if you wanted the way it applied to the facts. We have never permitted admissions programs to work in that way, and we will not do so today. At the same time, as all parties agree, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. But despite the dissent's assertion to the contrary, universities may not simply establish through application essays or other means the regime we hold unlawful today. A dissenting opinion is generally not the best source of legal advice on how to comply with the majority. But that second part is not what Harvard is quoting in their email sending around to their boosters and to their community, right? It's the first part saying that, at the same time as all parties agree, nothing in this opinion should be construed as prohibiting universities from considering applicants' discussion, right? So that is going to be the first, I think, battleground that they try to arbitrage in this fight is saying that, we're not making a data point calculation. We're just letting these people, and it's whoever can mirror and virtue signal the best based on the current doctrinal orthodoxy, right?
Well, here is a thought. Are we going to have an equal justice amendment to the Constitution? Are we going to have a movement to amend that now? And I haven't seen any intimation of that yet, and I don't know quite what it would look like. But things are so divided in this country right now, and the reparations movement has such a broad intellectual and respectable, even though I disagree with it, intellectual infrastructure. I have to imagine that within that camp, there's a sense of desperation this morning, because if you can't discriminate on the basis of race for education, how are you going to do it in terms of paying reparations and giving taxes? And I wouldn't be surprised to see an equal justice, some sort of, I don't know what it would look like, a 3/5 amendment, white people, for the next 220 years, or 3/5 the black person or something. I don't know. Does this ruling apply to other forms of diversity like LGBTQ? Arguably it does. And I think maybe not arguably. I mean, I would say certainly it does. With respect to race, we gave race a special place in American law and bent the rules on account of race because of our unique history. And there's really no denying that history. Who's going to come forward and say that that lesbians in the 1800s were so historically discriminated against that their progeny today's prospects are limited? It's hard to imagine that case being made. I'm hopeful that this case spells the death of DEI, and a recommitment to traits that we share, or to characteristics that we share in common, rather than traits that we're born with or that we are arguably born with. I think that would help to build a better republic. But Dawn, you're a sociologist by training. You told us the other day, you're just talking to a couple ham and egg lawyers. I can tell you that this case is a goldmine. Mike and I have been talking for a couple of years now about potentially creating something to litigate claims of race-based preferences in the reparation context. And we've never gotten very far in those discussions. Mike might not even remember them anymore. But I think this will energize those litigation claims, and there'll be a cottage industry on them now.
Well, and what I've put on the screen is from today in the New York Post. Sparks fly at California's final reparations task force meeting. Now's the time for a divorce. And
yeah, well, I'm thinking that is good. Hit the road, Jack, and don't you come back no more, no more, no more, no more. I mean, does anybody have a piece of dynamite I can put on the San Andreas fault?
Well, look, I mean, here's just a part of this. It said the meeting sparked with the second speaker, a black man named Reggie Romaine, who claimed that what the board had recommended.
Oh, wait a minute. Reggie Romaine, that's cultural appropriation. He's what am I going to do with my lettuce from now on, Who
claimed that what the board had recommended in payments is not enough.
Oh, yeah.
He suggested that African Americans get half the country after divorcing from the rest of America. He began by saying, quote, "This reparations task force, I appreciate y'all, but you all opened up a whole can of worms. I'm going to tell you this. Reparations is about repair. To me, I qualify. I'm going to tell you how you repair this. First of all, America, from the evidence that they gave us, you're guilty." He said, "In 1619, we were eating fool food. You kidnapped us, put a hate crime on us. That's the first one. Now you came in here with all the other atrocities. When you brought us here, you raped our men, women, and kids, so therefore you married us. Don't treat us like no cheap piece of meat," he exclaimed before pushing for a national divorce. "So therefore, our last name's American. So now's the time for a divorce. What do you get in a divorce? You get half the money, half the land, alimony, child support, attorney fees, and everything else. So that's what we want."
Yeah, well, of course we want it, and I would like, I would like to win the lottery tomorrow and retire to my place in Vermont and read obscure books and write essays that no one will read. That I would be happier than a pig in a sty, but it's not going to happen. The reparations debate is going to get a little more intense. Let's quickly flash to Robert Kennedy. We've had some interest in his comment. I mean, Robert Kennedy, Mike's been kind of digging and grooving on Kennedy lately, but he sort of
I've been interested in him because of how controversial he has appeared to the political left. It seems like the political left was is the side that wanted to reject him the most. And I think I said to you, Norm, that he had actually just gotten on the others before sending this tweet out. It was like the day before he was on some sort of town hall and had actually really, in my opinion, reshaped the dynamic and the narrative around him being anti-vax in a really persuasive way. And then he comes with this, and I'm left sort of, kind of just saying, okay, well, this is sort of the Democrat platform in a nutshell, right?
Well, it is. And of course, the last sentence is capable of double meanings. The effects of racist policies are going back centuries and now are self-perpetuating. I would go ahead and say they are. Look at what we just read from the California reparations movement. I mean, at some point, Justice Roberts famously said in a case involving the Seattle School Board, the only way to stop discriminating on the basis of race is to stop discriminating on the basis of race. The Supreme Court invites us to do it today. I encourage you all to do so in your interactions today, and let's rebuild a better world, one handshake at a time. Mike, let's wrap it up. I got to get to court. It turns out to be an African-American guy on trial,
Well, look, because you live a dynamic life, Norm. You know how to have principles and then apply them fairly. But
Maybe.
that may be a lot to ask in today's society. Anyway, thank you everybody for being here. We will be back Monday, 8 a.m. And you can find us on YouTube, Rumble, Twitter. You can rate us 5 stars on Apple Podcasts and any podcast platform. I see Norm stirring there, so Norm, get the heck out of here.
Go out, people. Talk about the good life. Talk about what draws you together with others. Talk about what we share in common, and let the dividers go. If they want a divorce, hit the road, Jack. Don't you come back no mo, no mo, no mo, no mo. But we want you to come back. See you next week. I'm off to court. Objection.
See you later. Overruled, counselor. Bye, everyone. Thank you.